Hello, I'm John Saltarelli, the managing attorney for Ross & Matthews, your Texas Legal Shield provider firm. I'm here to walk you through the basics of estate planning. I'm just going over general information, so remember, these concepts do not constitute legal advice. The best way to know whether any of this information applies to your situation is to call us and discuss it with one of our attorneys. Let's talk about a problem that affects most Americans: dying without a will. Studies show that over half of all Americans die without a will. That's a big problem. 3 of the most common reasons cited by survey respondents for not having a will are procrastination, a belief that they don't need a will, and the cost of having a will prepared. The will benefit available with the Legal Shield membership addresses and resolves all 3 of these issues. First, what is your estate? Your estate includes all the assets you've accumulated during your lifetime. It includes real estate, bank accounts, stocks, bonds, retirement plans, vehicles, household goods, personal effects, and anything else you own or control, such as life insurance or your business. Estate planning accomplishes 3 goals. First, to manage your estate during your lifetime. There may be events in your life, such as an accident, chronic illness, or a debilitating condition that prevents you from managing your own finances. Anticipating these situations and making calm decisions now, rather than under the stress of one of these events, will help others make informed decisions on your behalf later. If you wait until it's too late, it may be necessary to have an expensive and time-consuming court proceeding to designate someone to manage your affairs. The second goal is to arrange for a timely and cost-effective distribution of your estate upon your death. If you have a clear plan of what you have and to whom it goes and in what proportions, then this can reduce problems, costs, taxes, and ease the burden of your death on your loved ones. Finally, having a good plan will help save you unnecessary costs and time. Having a properly drafted Texas will can make probate less expensive and lessen the time involved in probating your estate. There are consequences to poor estate planning or no estate planning at all. If you don't explain your plan clearly, there could be incorrect assumptions about what you want, and your wishes may not be carried out properly. No planning or poor planning could lead to higher costs of distribution. Poor planning could also lead to higher taxes and less of your estate going to your loved ones. Now, let's discuss some common tools that are used in estate planning. The first is power of attorney documents. These are a very important part of a good estate plan. A statutory durable power of attorney designates someone to make decisions regarding your assets or your finances when you are incapacitated, meaning that you are unable to handle these matters yourself. You also need a medical power of attorney, which designates someone to work with doctors and make medical decisions when you are incapacitated, again meaning that you are unable to make your own decisions. You should also have a directive to physicians, informally called a living will, which is a document where you can give instructions about the continuation of life support in certain circumstances. Then, there are contracts that feature a beneficiary designation. Certain asset transfers are controlled by contracts. For example, proceeds from life insurance, annuity contracts, IRA accounts, and pensions will pass to whomever you have designated as your beneficiary on the beneficiary forms associated with those contracts. Contractual assets will pass without regard to the contents of your will and without probate, and supersede any conflicting provisions in your will. It's important to coordinate the beneficiary designations in those contracts with the provisions of your will to ensure that they work in concert with one another. Next is the last will and testament, which is a document that designates the persons who will receive your estate and in what proportions upon your death. It also addresses who will oversee the administration of the estate and addresses issues such as guardianship over minor children and management of assets left to minors. Both the named member and the member's spouse should have a will prepared. Upon your death, your will is then probated, which is another word for the process of carrying out the terms of your will, so that your estate passes according to your directions. Conversely, intestacy, or dying intestate, means that you died without a will. Texas has a law of intestate succession providing to whom and in what proportions your estate passes in the absence of a will. It's what the law presumes to be your estate plan. Problems come into play if you had more than one marriage, if you have stepchildren, or if you don't want to give your estate to your children in equal shares, and many other situations that arise in our lives. You lose control over the distribution of your assets if you don't have a will, and the results may be undesirable for you. At Ross & Matthews, we make it easy to start the estate planning process. Our will questionnaire is designed to collect all the information needed to help you complete the process. As you work through the will questionnaire, there are a few areas that may need special attention. Let me help you with those. Questions 1 through 12 are just asking for general information. So let's start with questions 13 and 14 with respect to minor children. Picking the people who are going to be responsible for carrying out your wishes takes some care. The guardian for children and trustee are important choices. We recommend that consideration be given to responsible family members or close friends. You are asking these individuals to take care of your children and to take care of your children's property. Before designating someone, call the person to discuss this very important decision and make sure that they are able and willing to take on the responsibilities. You are also asked in question 14 at what age your children should receive your estate. Please consider that even the most responsible child is probably not trained to handle money at the age of 18. Please consider whether this age should be 21, 25, or possibly even older. Question 15 is the heart of the questionnaire. Answering this question tells us what happens to your estate when you die. Be as specific as you want. Let us worry about the wording. Please remember that your will does not control who will receive non-probate assets, such as retirement accounts, jointly held property, life insurance proceeds, and pay-on-death accounts. Question 16 discusses disinheriting any children or grandchildren. Please take time to think about the effects of leaving out a child or grandchild on your remaining family. It's your choice, but please decide carefully. Your choice of medical power of attorney on question 17 is also a very important decision. This is the person that will carry out your health care wishes if you are unable to do so. It could be your spouse, adult child, or a close friend. Question 18 asks about the appointment of an executor. The choice of your executor is an important decision. This person has the responsibility of making sure that your estate is distributed correctly and any debts and taxes paid accurately. Please have a discussion with the choice of your executor to make sure that they are willing to serve. Your assets and liabilities, question 20, does not have to be exact. You can use ballpark figures. This page is more of a reminder of the types of assets that you may have overlooked and a note to the estate of any debts that you may owe that will need to be paid. Please note also whether or not you own any real estate outside of the state of Texas, as this may need to be handled in a different manner. Remember, the will questionnaire is not your will. It needs to be completed and submitted to Ross & Matthews in order to begin the process of having your will prepared. Your will is completed when you sign it according to the instructions given by us. Because every situation is different and every family is different, please understand that this video was only developed to give you an overview of the process. You should not rely on this overview for legal advice. Having an estate plan is important. It may seem like an overwhelming project, but Legal Shield is here to help you get it done. Our friendly and knowledgeable attorneys are always just a phone call away. They can help you decide on the right plan for you and help you implement that plan. Call us today at Ross & Matthews and let's get started. And as always, thank you for being a valued member of Legal Shield.